Yeah. Good morning, ladies and gentlemen, and welcome back to another episode of PLA with myself, Nick and Bruno. We've got three questions today. I will do the first one with Nick. Both gentlemen will do obviously the second question, and then the third one we'll do with Bruno as it's a vet question. The first question goes as follows here, Nick. They said they had a tenant in one of the units that was sold. The tenant renewed the lease in February 2024 for 12 months. Uh, he was then given 2 months notice on the 25th of April 2024 as well to vacate the unit on the 30th of June 2024 due to the property obviously being sold. Now, when the lease was renewed, we invoiced the tenant a 750 Rand lease renewal fee, which the tenant then failed to pay. When I processed the damage, when I processed the damage deposit, I took this 750 from the deposit where we were holding. The tenant has now had an admin lady from a law firm sending them an email advising that they request that the owner agree to waive or be liable for this fee. Only 1 month after the tenants renewed their contract, they were given notice to move. The tenant had to find alternative accommodation and to pay admin costs at the new accommodation. It cannot be expected of them to pay 750 Rand if they only stayed on for another 2 months after the contract was then renewed. So they're just asking for advice here, Nick, in terms of if the tenant has the right to request the seller to pay this 750 for the lease renewal fee. Nick?
So what's interesting about this question is this is going to come down to one of those strict interpretations of contract between the parties, and we're going to compare it to practicality within contracting between parties. Now, in our law, remember, we have freedom of contract and parties can contract as they want. And for the most part, the law is going to uphold the exact agreement that the parties came to within their contract. This applies to lease agreements, but it applies to all contracts entered into within our law generally. Okay, and unless there are very specific instances, like we often talk about the Consumer Protection Act, where there is some sort of legislative adaptance of the contract, generally the law is going to apply the contract exactly as it stands. Okay, and the only real hindrance to this is where perhaps terms are so against public policy that the law doesn't feel that it must uphold them. Okay, so these are contra bonos mores terms of a particular contract. They are deemed to be unfair and shouldn't be deemed to be enforceable within our law. Okay, but those kind of terms are very kind of rare sort of terms. It's not something that in a practical sense you run into very often. And I'm not even saying that it's something that's unfair in this particular contract. Okay, but what I'm saying is, in terms of the contract, obviously we don't have the benefit of the contract in front of us, but as far as I understand it, contracts will say if there's a renewal, there's going to be a renewal fee, and that's going to be the 750 that's pointed out within this particular contract that gets levied at the time of the renewal. All of those boxes in terms of this particular question tick for me. Okay. So strict interpretation, if I was reading the contract that has been entered into between the parties, it seems to me that there is no problem from a legal perspective of the 750 Rand. Okay. And it also seems to me that there is an acknowledgement of that fact, because the letter that's now come from the law firm is not demanding repayment. They're saying that it would be unfair in the circumstances to expect the tenant to bear a 750 Rand payment, and they're asking the landlord to consider refunding that 750 in light of the fact that the tenant didn't cause this problem, and they've only had a renewal of 1 month, but that's the landlord's election in the circumstances. So from a legal perspective, a strict interpretation, the landlord probably doesn't have to refund the 750 Rand. Okay, it's probably fine because for them to have levied that. From a practical perspective, and sometimes, Bruno, lawyers do have to look into their hearts and see how to practically solve solutions. Okay, we see this all the time with lawyers. Strict interpretation gets you one way, and it's one way of solving a problem. But it's not always the best way of solving a problem. And I think this is one of those circumstances. If it was my client, I would say to them, look, the insistence on the 750 rand, it's probably something that's not going to break the landlord's bank, and the sale of the property and the notice given. Remember, even if the property was sold, that doesn't necessarily mean that the tenant had to be given notice. That's a choice that the landlord made in the circumstances, depending on the terms of the sale agreement that they entered into, whether vacant occupation was given or not. The landlord could have well said, I've just renewed with my tenant for a period of 12 months or whatever the case is. And so you're going to get a property with a tenant in it. So the fact that the landlord has got themselves and the tenants into this particular situation is one of those circumstances I would suggest to the landlord, look, you're probably fine, and it's very, very unlikely that anyone is going to take you to a court of law, even a tribunal, over a 750 rand dispute. But this might be one of those circumstances where you take a knee and refund them the 750 rand, walk away with a bit of a better taste in everyone's mouths in the circumstances. I think that's the better resolution. Sometimes the law isn't always the fix that's required in a dispute.
No, absolutely.
Yeah, so yeah, thank you very much, Nick, for that one.